Good morning, good afternoon, good evening. This is a great pleasure for me to open the celebration of Environment Day, which in fact is a celebration of Environment Week from an environmental law perspective. It is the first time that WCL celebrates Environment Day and Environment Week, and in this case, with five major events addressing some of the most important issues that we face globally, of course, from a legal perspective. We have an outstanding group of colleagues as speakers today. As the main organizer, my colleague and friend, Professor Jorge Vinuales, and my dear friend and colleague, Professor Christina Boyd. They will introduce the speakers, and I repeat, some of the finest experts on this theme. In, in this case, the Stockholm Conference, its product, especially uh, the Stockholm Declaration, and everything else that came after that. So Professor Vinuales and Professor Voigt will introduce those outstanding speakers. As a welcoming, I would like to invite my colleague and friend, Professor Nicholas Robinson, to say a few words because of our all colleagues from the World Environmental Law family that I know. He's the only one that was there in person in 1972. And Professor Nicholas Robinson has been since then, and I would say before then, a pioneer in the development of environmental law from a theoretical perspective, but also addressing fundamental issues of compliance and enforcement at the international level, at the domestic level, in common law, and in civil law countries. Professor Nicholas Robinson.
Well, thank you very much, Antonio. It's a great privilege to be with you all today and to open in a ceremonial way this extraordinary 5 days of thinking about the challenges of environmental law in our era of the Anthropocene. When I went to Stockholm in 1972, I was a young lawyer. I thought this was the most wonderful thing that could be happening. The United Nations was going to finally put the environment on the agenda, something that had not gotten on in 1945 into the Charter of the UN. Environment was still something left for conservationists to worry about. And I met Wolfgang Borhenny and Françoise Borhenny-Guillemin in Stockholm at that conference. At that time, the IUCN's Law Commission only had about 16 jurists as members. We did not have a large family of environmental law. In fact, the governments really didn't know what to do with the meeting either. Many of them sent, along with a diplomat, they had to send some experts, so they would send their wildlife expert, the fish and game people, La Chasse. They would send, some sent the meteorologists, thinking that this was more about weather. Many sent their timber authorities and their lumbering industry. The UN Food and Agricultural Organization, which was still and still is one of the leaders in this area, was bringing in agricultural and silviculture specialists, and those states that were active with FAO did the same. IUCN, as I said, was a very young organization in a way, and not used to coming to diplomatic meetings. So it was quite exciting. And At that time, there was an agreement we had to do more to protect the oceans, but it took another 2 years before the London Dumping Convention could be negotiated, the first effort to begin restricting our use of the oceans as a great repository of waste. There was also a huge debate going on, mostly in the corridors, about the issues of weather modification pursued by the United States in the Indochina War, the Vietnam War that was going on, and great distress that Agent Orange was being used as a defoliant, a chemical agent of warfare. This led to the negotiation of the Environmental Modification Treaty, the ENMOD agreement, and to the effort to restrict the use of the environment as a weapon in armed conflict. So those issues were much debated, but not resolved at that conference. What you will hear about today, of course, was the great accomplishments that this early band of environmental cooperators, I would say, tried to put together in terms of the Stockholm Declaration. I must say Stockholm was a most generous city. Sweden rolled out all goodwill for this meeting. The weather was very good, as I recall. And it was a privilege to be able to be there at the birth of the UN's efforts in environmental law. This was the beginning of the launch of the UN Environment Program. And as you'll hear in these next 5 days of commentary in WCEL's program, we have come a long way. We have a long way to go. All the issues at Stockholm are still with us, still unresolved. So thank you very much, Jorge, for this wonderful event, Christina, and thank you, Antonio, for inviting me.
Thank you very much, Nick.
Many thanks. Oh, sorry, Jorge.
Please, Antonio. I mean, you're the maître d'orchestre.
No, I'm just, we're still in this formal opening, and I'd like to thank Nick Robinson for his very brief historical introduction. 3 last points. One, to thank our very small team that has worked tirelessly to put together the event, especially Emily Gaskin. It's 4 a.m. in Seattle, and there we have Emily Gaskin with us up very, very early. Let me also thank Professor Jorge Vinuales. Immediately after contacting him, he accepted being the coordinator, not 1 second of hesitation, and Professor Christina Boyd for helping us with the design of this day and the following days. The other point that I would like to stress is we begin with Stockholm, and the question is, does it matter? And to me, it matters tremendously. First, because it's not an exaggeration to say that everything at that level, internationally, but also nationally, for many countries, it started in 1972 in Stockholm. Second, it matters because if we examine the jurisprudence on environmental law in most parts of the world, especially in Latin America, we are going to see that no other document is more cited than the Stockholm Declaration, which is quite interesting. It's not hard international environmental law, and rarely we see the CBD, the climate change conventions being cited, or even CITES or Ramsar. But the Stockholm Declaration is everywhere. It's also absolutely relevant because if we look at constitutional provisions addressing environmental protection, even those that were enacted after 1992, after Rio 92, we are going to see that the vocabulary used still is the one that comes from the Stockholm Declaration. Much later, those new constitutions in constitutional provisions will incorporate a different vocabulary coming from Rio 92. And finally, to me, opening this 5-day series with the Stockholm Declaration, as Professor Robinson just stated, is a way of reflecting about the evolution and addressing the successes. Environmental law is or has its history of successes. We should not forget this. Nature, the environment, would be in a much worse situation if it were not for the environmental rules that we have been able to bring to life at the international, national, and subnational levels. On that note, let me again thank everyone, and I'm sure we are going to have a fabulous event opening 5 days of fabulous events. Jorge, thank you.
Thank you very much, Antonio, and thank you very much, Nick, for these introductions. I think we're very lucky to have IUCN and also with Nick's perspective. I mean, Nick has been shaping the field, not just at the domestic, but at the comparative and at the international level for decades. And I think we're very lucky to have both of you opening this introductory segment on this first seminar out of 5 that will be punctuating and commemorating World Environment Day in this week. Now, the purpose of my very short words, and I will be introducing our 4 fantastic speakers in just a little while, but the purpose of my words is really to try to situate a little bit the seminar. So the entire idea for this seminar is to ask a question, a simple question, and actually to address what could be felt as a puzzle. I guess that at this point, it is entirely obvious. It is entirely obvious that we're doing something wrong when it comes to dealing with the environment. There is so much law, there is so much discussion, there is so much evidence that we have to change the ways in which we are dealing with our environment, that it is very striking, it is surprising actually, that we have not yet come up with binding global legal principles governing that relationship. It is striking, it is really striking. It's like playing chess without agreeing on the rules of chess. And in a context where the outcome of that chess match is not just important for the tiny little players or even for the tournament, but for the entire community, the biosphere, the community of living things in the earth. Now, it's very important that we realize that it is high time for us to come up with clear, binding legal principles shared by everyone. And as Antonio was saying, there is hope. Some of the principles, in this case, I'm talking about the standard of cares in Dutch law that takes up the idea of due diligence in international law or prevention in international law, has been brought to very, very specific bear just this week in a case against a company, an oil company in the Netherlands. So I think we will have an opportunity to discuss perhaps that later, but that will be one of the main areas of the second seminar for this week. Now, with those very basic introductory words, let me perhaps say a word about our four stellar speakers. The easy thing for me is that they need no introduction, none of them. But I will nevertheless introduce them very briefly in the order of their surnames.
Yeah,
so
Jorge,
the first, yes.
Just 1 second, because I forgot to introduce you. You don't
That's
need
a
any.
My name
You
is
don't
Jorge
need.
Villanes. I'm a
You don't
professor
need
in
any
the UK.
introduction. But let me just say that you are one of the stars, global stars on international environmental law and international law in general. As a professor of international law, director of a center, Cambridge University, and associated with several other universities, you are probably the most successful from an academic perspective lawyer in Latin America, but now an expert, a scholar that we have given to the world. So I think that's enough to say about you. And one last thing that I forgot, I was so enthusiastic about Stockholm, I forgot the logistics. There we have interpretation. This event is in 3 languages. You can go to the language button or icon, and you are going to find there the 3 languages, English, French, and Spanish. And you just select the language you want. Again, my apologies and many thanks, Jorge.
Thank you, Antonio, for this undeserved and extremely kind presentation. So let me just say a quick word about our panelists and then the structure of the panel. So we have Professor Jan Aguila from Sciences Po, and also the head of the coalition, the Global Coalition for a Global Pact for the Environment. Jan has been working very, very hard in the last years to get really to move this idea of a global pact of binding principles with the environment. And many of the people that are in this panel also are involved in that initiative. We also have Ambassador Marie Jacobson, who is a principal legal advisor on international law of the Swedish Ministry of Foreign Affairs, and a former ILC special rapporteur for a key area, which is the area of environmental protection in relation to armed conflict. We have Professor Makan Benge, who is the director of the Department of International Law and International Organization at the University of Geneva, also a member of the very prestigious curatorium of the Hague Academy of International Law, and a very prominent and sought after practitioner. And last but absolutely not least, this is just about surname, is Professor Christina Boyd, who is not only a professor of international law at the University of Oslo, but also the chair of the IUCN WCL Climate Change Specialist Group, and very importantly, also the co-chair of the Paris Agreement Compliance Committee, which is these days, I guess, it's the most prominent compliance committee and possibly specialized environmental quasi-adjudication body at the global level. It's very, very important to have these people that are not just at the forefront of thinking in environmental law and governance, but of action. I think that action should not be underestimated in this area. Now, on the structure of the seminar, it's very simple. I will be asking broadly 4 questions, broad questions that try to address different dimensions of the puzzle. One question is about the history. Another question is about the legal manifestations and acquis, the achievements. Yet another question is about the resistance, or the elements that may explain why we don't have yet those binding principles at the global level. And then, of course, the 4th question about the prospects. And then we will move to a Q&A session where we will be taking a couple of questions. Hopefully, every 3 questions will give the speakers the possibility to answer. A last point from me, and then I will turn immediately to the first question, is that I would have liked to chair this panel in Spanish. I'm from Argentina, and I think that it's very important to have a diversity of languages in this area, but it would have been impractical for me to do so. So This said, the different panelists and speakers are free to select the language that they want to. I mean, they can speak, of course, in English, but they are free to select the language in which they want to make their remarks, either on the questions of the Q&A later on. So this is something that, as Antonio was saying, we're very privileged to have an interpretation service that is operating. So without further ado, let me really go to the first question and perhaps start our conversation with a retrospective look at efforts to formulate principles governing our relationship to the environment, so the audience has a clearer picture of the context. And perhaps if I can start with Christina, who has written extensively on these questions, particularly on the principle of sustainable development. Christina, can you tell us a bit more about this retrospective look that Nick has already introduced with his experience in Stockholm?
Thank you, Jorge. Thank you for your kind introduction. Thank you also to this question, but thanks also to Antonio and Nick for your introductory remarks, and a warm welcome to my fellow panelists. I'm very much looking forward to the discussions today. Jorge, back to your questions about looking back on our relationship or the attempts to define principles of the relationship to the environment. I think looking back would probably take us a very long time back, because I think attempts to formulate principles of relationship with the environment are probably as old as humankind itself. We all know the late Justice Christopher Parliamentary Justice at the International Court of Justice, who has looked into the history of environmental principles, in particular sustainable development, but also others. And he stated that the need to reconcile development with the protection of the environment was already noted millennia ago. And he gave interesting ancient examples of irrigation techniques in the Sub-Sahara or in China or in Southeast Asia or South America. So it's been a long time coming. But the question is, these relationships with the environment that we find in so many cultures and so many religions, how do they translate into law? And here we're really entering today's topic, because we have very rich international law and we have international declarations. And I'll just try to give a very brief overview over where we started and where we are now in 2021. I think one of the earliest awards that we have in international law that pretty much established the principle that no state can use its territory so as to cause environmental damage to other states is from the early 20th century, and it was a bilateral tribunal award between the state of Canada and the state of Washington in the United States, which was based on a dispute concerning the fumes from a zinc smelter, the Trail smelter, that was causing damages, air pollution in the United States. And from that crystallizing moment of the Trail Smelter Award, we've seen a really strong development of a focus and work on environmental principles. Of course, the Stockholm Declaration we already heard about, and we'll talk about it much more through the course of today, from 1972, set out a whole set of environmental principles, which from 1972 to this day, and next year is the 50th anniversary of the Stockholm Declaration, have been incredibly influential, both in decision-making, but also the further development of environmental law. Other examples are the 1982 United Nations World Charter for Nature, a UN resolution, which is very worthwhile having a look at it. It established in its principle 1 that nature shall be respected and its essential processes shall not be impaired. And as Jorge said, science is pointing the other way, and it might be really important to look back at these earlier examples of environment or formulation of environmental principles. In 1987, we have the report of the Bruntland Commission, the Commission on Environment and Development, which was chaired by the then Norwegian Prime Minister Gro Harlem Brundtland, and the report was called Our Common Future. And of course, our common future is this planet. And the report itself set out a number of principles, most famous, again, the principle of sustainable development, which is defined as development that meets the needs of the present without compromising future generations' needs to meet their own needs. But interestingly enough, it had an Annex 1, and the Annex 1 was prepared by the legal experts of the World Commission on Environment and Development. And that Annex 1 contained proposed legal principles for environmental protection and sustainable development. And it set out these principles in a very clear manner. For example, that all human beings have a fundamental human right to a clean and healthy environment. It set out the principle of intergenerational equity, of cooperation, of conservation and sustainable use, and so forth. And then in 1992, of course, we had the Rio summit in Rio de Janeiro in Brazil, which ended with the Agenda 21, but also with the Rio Declaration, which Antonio did not mention, but is probably equally important in terms of references to it by decision-making, both administrative, legal, and adjudicative. The Rio Declaration set out 27 principles. It also reaffirmed the Stockholm Declaration, and you, Jorge, have edited a wonderful commentary, of course, on the Rio Declaration's principles, which is a very important standard of reference. And then, since 1992, we have pretty much seen two parallel tracks of development with environmental principles. One is further declaration of principles in non-legally binding declarations, in political declarations, and we've seen the other track, which goes more into the codification, legalization of environmental principles. First to the political track, where we've seen pushes and initiatives and thinking around environmental principles. For example, we have the Earth Charter from 2000, which sets out 16 environmental principles that define the relationship between man and nature. We have the IUCN Draft International Covenant on Environment and Development, again, which is an attempt to consolidate and develop further environmental principles. We have another example, the 2010 Universal Declarations on the Rights of Mother Earth, which was adopted in Cochabamba in Bolivia, and where indigenous peoples had a very strong voice in the development of that declaration. And of course, we have the outcome document from Rio+20, the 2012 conference, and that produced the report, The Future We Want. But these are only some examples of further non-binding instruments that further push the development of environmental principles. But as I said, at the same time, we also have a stronger codification and clarification in a legally binding sense of many of the principles. We have since the early 90s, the adoption of international treaties, the Convention on Biological Diversity, the United Nations Framework Convention on Climate Change, the Paris Agreement, and many others, which do codify a number of the principles that we have in the Stockholm Declaration and in the Rio Declaration in a legally binding setting, in the context of a legally binding treaty. For example, the Framework Convention on Climate Change has an Article 3, which is entirely titled Principles, and which was further developed, of course, in the context of the Paris Agreement. We have seen further attempts to codification. The International Law Commission, as Antonio already mentioned, and Marie Jacobsen was involved and is working on further codification of law and principles, for example, with regard to the protection of the atmosphere, or sea level rise, and not the least on the protection of environment during armed conflict. In the field of the human rights area, we have a strong movement towards the recognition of an international UN-based human right to a clean and healthy environment, which is not yet in place. We had from earlier this year, from March 2021, a statement by 15 United Nations bodies and institutions that call for the adoption of a human right to a clean and healthy environment at the UN level. So we see many codification initiatives, attempts, results already happening where we have the legal anchoring of these early principles in binding international law. And finally, we also have very interesting developments in customary international law. As you know, these are not legally, not written treaties, but are still legally binding norms upon all states just by their recognition as customary law. And here the International Court of Justice has been very instrumental in defining and carving out what do we have in the area of international environmental protection, and especially the principle of prohibition of transboundary harm, of significant environmental harm, is one of the core principles that we have, which was recognized as being part and parcel of the body of international law. And this principle contains the principle of precaution, of prevention as well, and it is of course embodying also a due diligence obligation on states to do as best as they can to adopt their best efforts, their highest level of ambition when designing appropriate measures in their domestic legal systems. So we see a lot of development happening at the same time, both in treaty law as well as in customary law. And I think it is fair to say that perhaps the area of environmental principles is the most dynamic, maybe also the most vibrant area of international law, and certainly an area which is very fascinating to follow. Thank you very much.
Thank you very much, Christina. A very complete presentation of really a lot that is happening, and I think that it will be a very useful spring for the discussion in the next two questions of the legal shape, the legal form, the legal expression that all this work, this burgeoning work on principles is taking, but also the reasoning or the potential explanation of why this is not really concluding or leading to a single binding instrument. And before I move into those questions, let me just ask perhaps briefly to Jan about some aspects that field of principles, and particularly the Global Pact for the Environment. Jan, would you like to say a quick word about this initiative in the context that Christina defined so far?
Yes, with pleasure. And I'm going to try to speak in Spanish for this intervention so that the three languages are represented. And please excuse my mistake. So, como ha señalado Cristina, la iniciativa más reciente es el Pacto Mundial por el Medio Ambiente. Y tuvo la suerte de ser uno de los iniciadores de esta idea junto con Laurent Fabius, el padre del Acuerdo de París. En un primer momento lanzamos la idea con un pequeño grupo de abogados en Francia, el Club de Juristes, y luego se elaboró un proyecto de pacto en 2017 por una red internacional de 100 abogados, con muchos que están presentes ahora. Y al principio fue un tremendo éxito. La Asamblea General de las Naciones Unidas adoptó una resolución en el año 2018, y esta resolución se llama Hacia un Pacto Mundial por el Medio Ambiente y se adoptó con una increíble mayoría, 143 estados a favor y 5 solo 5 estados en contra. Y las negociaciones están en curso desde 2018, pero son difíciles. Hubo en particular una fuerte oposición de los Estados Unidos, de Donald Trump, de Brasil, de Bolsonaro, y en definitiva se ha producido una rebaja de las ambiciones. En un principio se deseaba un verdadero tratado, pero al final los estados decidieron preparar una simple declaración política, sin valor jurídico. Esta declaración debe ser adoptada en 2022 para los 50 años de Estocolmo. Todavía está en discusión entre los estados, así que debemos ser optimistas. Todo es posible en 2022, pero esta historia ilustra bien el título de nuestro panel: es un largo camino.
Es un largo camino, exacto. Muchas gracias, Jan, and thank you very much for representing the Spanish as well, because otherwise we would have missed it. Now that gives me the opportunity to move to the second question. And the second question is a bit more about determining the legal form that all these initiatives that Christina and Jan had been referring to have taken in actual practice and in legal practice. And perhaps I can turn to Makan, who together with Christina and another colleague were the lead authors of a 2018 report of the UN Secretary General on gaps in international environmental law and environment-related instruments, precisely in the context of the process that Jan was referring to. And the question would be, in what ways have the principles of international environmental law found legal expression over time, and what is really missing? Makan, what do you think?
Thank you so much, Jorge, and thank you very much to both you and Judge Benjamin for this very kind invitation. I'm very happy to share this panel with all these dear colleagues and friends. You know, Jorge, when you asked me about the legal manifestations of principles of international environmental law, I think that both you and me, we always remember what was said by the Iron Rhine Arbitral Tribunal in 2005. There is this famous paragraph 58 of the award of that tribunal, who actually said that there is considerable debate as to what within the field of environmental law constitute rules or principles. What is soft law, and which environmental treaty law principles have contributed to the development of customary international law. And you remember that the position of this tribunal was to say, I don't want to enter into those controversies. I don't want to enter into the controversies of what are the legal manifestations of principles of international environmental law. And the strategy of the tribunal was to say, well, you know, what I know is that they are emerging principles, whatever their current status, there are emerging principles that are out there, you know, principles relating to conservation, management, making reference to notion of prevention, future generation, and sustainable development. That was the position. So why do I like to refer to this paragraph of the award of the tribunal in the Iron Rhine arbitration? It's because I think it says it all. It says it all. What does it tell us when you pay attention to that passage? Well, it simply tells us that when it comes to the legal manifestations of principles of international environmental law, those so-called manifestations are characterized by a lack of legal predictability. They are characterized by a lack of legal certainty, and they are also characterized by a lack of consistency. This is what the landscape of principles of international environmental law offers to us. Lack of predictability, lack of consistency, and lack of legal certainty. So the question is why? And this brings me, of course, to the what is missing. The reason why the legal manifestations are very vague, very obscure is because principles of international environmental law are missing a lot. And you were mentioning the report that has been published by the UN Secretary General in 2018, entitled Gaps in International Environmental Law, to which both Christina and me have had the privilege to contribute to. So what this report is saying in terms of what is missing, you have a paragraph there, which is paragraph 102, which I think summarizes very well what is missing. And what paragraph 102 of the report of the Secretary General is saying is that there are important deficiencies. There are important deficiencies with respect to principles of international environmental law. And there are two main deficiencies. One deficiency is related to the content of principles of international environmental law. And the second deficiency, main deficiency, is related to the legal status of the principles of international environmental law. And so when we focus a bit on content, what does it mean? It means that for most of these principles of international environmental law, actually the meaning, the scope, the contours are not clear. And when the meaning, the scope, and the contours are not clear, it is then, of course, very hard to determine or to identify what should be the proper legal manifestation of such principles. Same when you have deficiencies regarding the legal status of such principles, it's also very hard from there to determine what is the appropriate legal manifestation that those principles should have. There is still doubt about what is the meaning of the principle of sustainable development. There is still doubt about what is the content of the precautionary approach. There is still doubt about what is the content meaning of the obligation to conduct an environmental impact assessment. Worse, there are still doubts about the meaning, content, scope of what is the right to a healthy environment. So if you have so many deficiencies on the principles that are supposed to be the core foundations of global environmental governance, then what does it mean? It means that global environmental governance cannot be efficient, cannot be effective, since the principles that are the serving as core are characterized by all these deficiencies. So this is the challenge. How do we correct, adjust those deficiencies to make the principles of international environmental law more predictable in their content, in their legal status, to actually determine the proper legal manifestation that they should have. Thank you.
Thank you, Makan. No, that's totally clear. Actually, it's the impression that the rules of the game are not entirely clear. So we're playing different games potentially. And perhaps if I follow up on that question, in what specific areas, what specific rights or duties? And I'm thinking about, you mentioned, Makan, the right to an environment of a certain quality. I was mentioning earlier today the application of environmental principles in relation to armed conflict. And perhaps I can ask, I would be very tempted to ask a question to Marie with respect to what specific areas, how can we improve the manifestation, the actual formal manifestation of these principles in some specific areas, Marie?
So sorry for the delay. Thank you, Jorge. Thank you, Antonio, Nicolas, Christina, Jan, and Makine, for having me on this panel as well. Can I ask you, do you hear me? Sounds, if it is difficult.
Yes.
So it's a great discussion already, and I wish I could comment on much more than question you asked me just now, Jorge, but I hope to get back to it in the end. Well, you referred to the protection of the environment in relation to armed conflict and what is missing. And what I think is that it's perhaps we don't really need a new formal treaty, but we need a compilation of principles that is drafted by the International Law Commission. I was, as you mentioned, the special rapporteur for that, and now my colleague from Finland, Maja Lehto, has taken over, and the principles are ready, finalized. They're out for comment for states to comment them and to give the International Law Commission the feedback on what they think about. What I find interesting, what I find interesting with the principles is that they were considered in a sense to be progressive when we started working with them. I started this work in 2010, 2011, and now the development that has been described by some of you already has almost caught up the ILC principles. So they shouldn't be as controversial as they were when we started to work on the topic. It was really difficult even to get the item on the International Law Commission's agenda. I think that Makane had pointed to something really important here, that if you don't have proper formal legal structure or treaties, we have a lack of legal predictability, consistency, and certainty. And I think that what is important when it comes to the protection of the environment and the principles that we list is the fact that what they can do, when we do not have a formal legal treaty, other entities like courts and tribunals will step in and interpret, and that's when they will make use of even what we can call soft law instruments. So I really hope that we can see that this, should I say, lacuna in both policy and law, in a sense, is mitigated by the work of the ILC. It is very often forgotten, it was very often forgotten, that we do not have a proper protection of the environment in relation to armed conflict, which is not only during armed conflict, but as important before and after. How do you repair a war-stricken society? How do you build a sustainable peace unless you have basic entrances into a sustainable development and peaceful development? I'll stop there. Thank you.
Thank you very much, Marie. It is indeed one of the, as Makane was saying, is one of the perhaps one of the explanations why there is so much difficulty to accept and enshrine principles into a binding legal instrument is precisely the lack of sufficient agreement on the very contours of these broad notions. And yet one can see that reasoning precisely from the opposite perspective and say, well, precisely because there is so much discussion and so much debate, the need for a clear statement of those principles arises forcefully. And that takes me to the third question for the panel. So it's, as I mentioned earlier, so one of the most puzzling aspects of this in this long process to this day is really that the binding principle or instrument formulating these principles of international environmental law, as one has, for example, in the areas of human rights with the 1966 Covenants and the 1948 Declaration, or the law of the sea in the UN Convention on the Law of the Sea, or even trade with the WTO agreements and the GATT particularly. So that is missing in the area of environmental law. And going back to what Jan was saying in Spanish, so as one of the leaders of this initiative for a global pact for the environment, and certainly I would say it's so, what are, in your view, Jan, the main reasons explaining this absence, possibly the resistance to the adoption of such an instrument?
Merci, merci Jorge. Je passe au français maintenant. Et effectivement, c'est une question que je me suis posée après les difficultés des négociations sur le pacte mondial pour l'environnement, qui étaient des difficultés surprenantes, puisque au début, il y a eu un grand enthousiasme des États qui ont adopté la résolution, je l'ai dit tout à l'heure, à 143 États pour, 5 États contre, donc une très très large majorité d'États qui acceptaient d'ouvrir des négociations. C'était l'ouverture des négociations. Et puis, des illusions ensuite au moment des négociations, mais qui ne sont pas finies. Mais des illusions, déceptions, parce que finalement, on s'est heurté à de grandes résistances. Et il y a sans doute des raisons très conjoncturelles, ponctuelles. Je citais des motifs politiques, par exemple, avec les États-Unis de Donald Trump, mais je crois que plus fondamentalement, avec le recul, nous devons nous interroger sur quelque chose de plus profond, de plus compliqué à faire évoluer, c'est les méthodes de décision de notre gouvernance mondiale en général et de notre gouvernance mondiale de l'environnement en particulier. Pourquoi ? Parce qu'avec un peu de recul, finalement, ces résistances ne sont pas très étonnantes. On essaye de décider avec 193 États. 193 États ayant chacun leurs intérêts personnels, ce qui est bien normal d'ailleurs, mais sans qu'il y ait au-dessus de ces États un intérêt public mondial qui soit considéré comme supérieur à l'intérêt individuel des États. Et cet intérêt public mondial, il est différent de la simple somme des intérêts particuliers de chaque État. C'est quelque chose de différent, c'est quelque chose de supérieur. Et toute notre architecture internationale, depuis le traité de Westphalie et depuis donc l'émergence de l'État comme élément de base de notre organisation mondiale, tout repose là-dessus. Et j'ai coécrit un article où nous imaginons avec Marie-Cécile de Bellis, avec qui j'ai écrit certains livres, nous imaginons un martien qui viendrait aux Nations Unies sur la Terre, et puis qui verrait ces petits êtres humains qui ont détruit une bonne partie de la planète, qui font face à une situation d'une gravité exceptionnelle. Une crise de la biodiversité sans précédent. Depuis Stockholm, puisqu'on fête les 50 ans bientôt de Stockholm, depuis Stockholm, on a eu 50% des mammifères en moins. On a eu depuis Stockholm 60% de la vie sous-marine en moins. Donc, une situation terrible. Et le martien regarde et se demande que vont faire ces petits êtres humains. Et imaginons-le survolant la COP21 ou toutes nos conférences internationales, et que voit-il ? Eh bien, ces petits êtres humains se mettent autour d'une table à 193 et ils discutent, et ils discutent, et ils discutent. Et c'est toujours la même histoire. Ça dure une quinzaine de jours, ces COP, ces conférences, et jusqu'au bout, on pense qu'il n'y aura pas d'accord. Parfois, il n'y a pas d'accord. Souvent même, c'était par exemple le sommet de Copenhague. Et de temps en temps, on rajoute un dernier jour d'espoir et une dernière nuit blanche, comme pour la COP 21, pour l'accord de Paris. Et finalement, après une nuit blanche de négociations, le négociateur, avec les cernes sous les yeux, frappe avec son marteau. We have a deal. On a un accord. Elle est là, la raison. Prenons un peu de recul. Est-ce que c'est sérieux? Est-ce que c'est rationnel comme mode de décision? Alors, je sais bien, on ne va pas changer en un jour ce mode de décision, mais nous devons nous interroger. Il y a tout de même en droit, dans la boîte à outils de la gouvernance, des outils qui nous permettent de décider plus facilement. Un organe international, une organisation internationale peut émettre des actes de droit dérivé qui sont des actes pris à la majorité simple d'un organe. C'est la règle de la majorité, c'est la démocratie. Bref, je serai trop long, mais ça explique sans doute cette méthode de décision, ce mode de gouvernance, explique sans doute une sorte de succession d'échecs. L'échec de l'Organisation mondiale pour l'environnement, l'échec ou les difficultés du pacte mondial pour l'environnement, l'échec ou la non-survenance d'ailleurs d'une Cour internationale de l'environnement. Tout se passe comme si il y avait un mur invisible, les projets ambitieux n'arrivent pas à émerger à cause de ce mode de décision. Alors bien sûr, il n'y a pas que des échecs. On l'a dit tout à l'heure, si on fait un bilan au bout de 50 ans de droit international de l'environnement, il y a aussi des réussites. Mais ces réussites ont toujours deux caractères. C'est soit du droit souple, on a beaucoup de droits souples qui n'a pas de valeur obligatoire, donc des déclarations, les fameux ODD, objectifs de développement durable, c'est du droit souple. Soit on a des accords très techniques de techniciens, comme les accords sur l'ozone, les accords sur les produits chimiques, les accords sur les déchets, les accords sur les émissions de gaz à effet de serre. C'est un droit de technicien, c'est un droit d'ingénieur. C'est ça le droit aujourd'hui international de l'environnement. Et évidemment, parce qu'il y a une solution de facilité, il est plus facile de s'entendre sur des questions techniques que sur des valeurs. Le problème, c'est qu'on a besoin de valeurs. Toutes les sociétés ont besoin, un jour, de poser les valeurs qui les rassemblent. C'est pour ça qu'on a dans toute société de grands textes fondateurs, des textes qui servent de boussole. C'est le ciment d'une société. On a des constitutions, on a la Magna Carta, on a la Déclaration universelle des droits de l'homme. Eh bien, aujourd'hui, le droit international de l'environnement, c'est un peu comme si, dans un pays, à l'intérieur d'un pays, on n'avait que des lois techniques, mais pas de constitution. Il nous manque une constitution écologique pour le monde. Et je pense que, et j'en termine avec ça, je pense qu'avec le Covid, on a peut-être une chance, parce que souvent, c'est des catastrophes qui font avancer l'humanité. Et pour être optimiste, peut-être que la crise du Covid pourrait être ce moment constitutionnel où les États se rassemblent en se disant nous avons des valeurs communes et nous devons les inscrire sur un texte fondateur. C'est ce que j'espère en tout cas, peut-être en 2022.
Thank you very much, Jan. Yes, indeed. Actually, there is this this very unfortunate tendency in international law to be disaster-driven. We've observed that with the foundations of international human rights law. We have observed that also to some extent with the foundations of international criminal law, with the International Criminal Court, although the ILC had done a prior work. With trade, it took I mean, something very important, but less important than what we're dealing with now. It took since 1947, actually since 1948 up to 1994 to actually get there. So there is a tendency to wait until there is a convergence, a configuration of political circumstances that enable that step to be taken. And in the meantime, I guess and that is in a way my other bodies, other international bodies such as international courts are stepping in to try to clarify some of these principles. I'm looking at what Makan was saying. Perhaps Makan, I mean, you mentioned that in the 2005 Iron Rhine case, the 5-people tribunal mentioned that here there is a lot of the lack of clarity, a lot of discussion. But since then, things have moved on, and there have been some interesting interventions by the International Court of Justice on what is part of customary international environmental law. Can you tell us a bit more about that, Makan?
Yes, thank you, Jorge, for giving me the floor again. Well, you know, when it comes to the contribution of international courts and tribunals, I agree with you that there is no doubt that they have contributed to some developments in the field of the international law relating to the protection of the environment. But what we can see also when it comes to international jurisprudence or case law regarding to principles of international environmental law is that it is characterized by a lack of judicial consensus. It is characterized by a lack of judicial consensus, which actually kind of, exacerbate the fragmentation within the so-called customary international environmental law. And this is why, although I agree on the need of having a global legal instrument that would render all these principles predictable, because I don't believe that it is for the international judge, for the international adjudicator to play the role of a lawmaker in the system, in particular when the lawmaking is characterized by a lack of judicial consensus. Just think about, the divergences between universal courts and regional courts. You have most universal courts that would tell you that due diligence is an obligation of conduct. You go to Africa, you have courts in East Africa, in West Africa, that actually say that due diligence is, based on an obligation of results. That's just an example. But if I assess with a little bit of distance the contribution of international courts and tribunals to the customary international environmental law, I would use the two qualifications, sorry. Dry and shy. They are dry on the content of customary international environmental law. When courts are not very able, for instance, to clearly indicate what should be the international criteria to conduct a proper environmental impact assessment, for me, this is dry. Shy. They are shy on the determination. They are shy on the determination of customary international environmental law. Let's just think about the precautionary principle. The most progressive international court was the Deep Seabed Chamber of the International Tribunal for the Law of the Sea, which in 2011 or 12 said that precaution is now crystallizing in customary international law. So that was great. But then the next line, that same tribunal is telling us, oh, I'm not the one saying it. It's what the International Court of Justice said in the pulp mill case in paragraph 164, but we all know that the International Court of Justice never said that in the pulp mill case. So shy when it comes also to the very existence of customary international environmental law. Yes, there are developments there, but these developments need to be reinforced, need to be accompanied with a global, predictable, binding instrument that would render all these principles more certain in their content and contours. Thank you.
Thanks, Vakan. And possibly we have a chance to actually rediscuss these principles at the conference that will come. And this is really my fourth question to the panel about the prospects. And as several of you have mentioned so far, in 2022, a major conference commemorating the 1972 Stockholm Conference on the human environment will be organized. And in the 50 years since Stockholm, our understanding of how pressing and existential our environmental crisis has really moved from the fringes of the agenda to very high up in the political agenda, although action is still falling behind. And Marie, as a leading voice for action on this pressing issue, what would you like to be the outcome of this Stockholm+50 conference to be held next year? And you think is it covering most of the issues or only one, some of them? What is missing there?
Thank you, George. And let me say perhaps a few words about the process. I mean, we know now that there will be two conferences that are as important. One is the Stockholm +50, and then we have the UNEP at 50. And there was a resolution adopted last week in the General Assembly, which clearly sets out what is called an enabling resolution that sets out that now it is time to move on. We will have a resolution negotiated in the summer, hopefully to be adopted in the fall, about exactly how the Stockholm Conference will take, what it will contain, how it will be conducted, and so on and so forth. And these are very important negotiations. We all know that. Those of us who are engaged in the major conference of the ocean knows that it almost took a year to negotiate the modalities resolution. But we know that the Stockholm+50 will be held next year during the World Environmental Week, around the 2nd and 3rd of July here in Stockholm. And we also know from the resolution that was adopted last week that the aim is that it should result in a summary of the discussions. That doesn't sound very much, and that goes back to Jan's Martian who is entering the Earth and is looking and say, what is this? Only a summary of the discussion. Will this ever lead anywhere? But I do think it is important because as all of you have pointed out, these are important steps, and we shouldn't underestimate what such a summary of discussion could bring about for the future. There is no way for me to see what we can expect, and that means also there is no possibility for me to say what is lacking, what would be lacking in that conference as a result of the conference. But I'd like to say that I think that there are, for me personally, apart from, of course, wishing on a mere personal note that we had a global pact for the environment adopted, but there are three elements that I think are very forgotten, and we need to put forward much more than we do. One is, of course, the relation between armed conflict and the protection of the environment, and it's sort of, as I mentioned before, it goes far beyond the international humanitarian law applicable only in armed conflict. We're talking about precautionary measures, and we're talking about remedial measures. And this is why I think it is so important what the ILC is doing. There is a reference to the importance of the principles also in the Global Pact for the Environment, but I do think we need to shed a light on this and emphasize the importance of this Article 19 in the Global Pact for the Environment. I also think that the very well embraced principle of intergenerational equity that was referred to by Christina, and I thank you for the reference to Bruntland report, the annex. I think that is very important that we go back. But I do think it is important that we turn this, should I say, political statement and ensure that it becomes a proper legal basis, a basis to act on. That will connect this principle with jurisdiction, what courts have the right to bring up this issue of intergenerational equity before a court case, etc. I think that is a real challenge, but something we need to look more into. And thirdly, I think there is far less attention to environmental defenders. I know that we have environmental defenders and the risk they are running when they defend the environment is more and more observed internationally. The IUCN has also done a report, and in Latin America you are very well aware of this, but this happens also elsewhere in the world. And I think, and there is a very clear, and I'm very grateful for the IUCN for this report, there is a very clear gender aspect to this. There are very often women that are squeezed between state governments and private sectors. We need to stand up for those who defend the environment. We need to show that this is a human rights issue, and we need to make a legal connection between their right to speak out and to act and basic human rights principles. So these three angles, protection of the environment in relation to armed conflict, making intergenerational equity, to forming it from a political or semi-legal principle into proper legal rule, and environmental defenders, particularly gender aspects. These are the three aspects that I think we must get. Thank you.
Thank you very much, Marie. And actually, these are three key issues, and precisely because Christina mentioned intergenerational equity, perhaps she could share some ideas on not just intergenerational equity, but how we could make the most of this new momentum, this new opportunity, aside from the technicalities of the conference and the scope of the conference and the limits of the process. How could we make the most? What could be some good ideas, some good initiatives to put forward in these years where we're relaunching the environmental architecture or the environmental governance architecture to commemorate the Stockholm moment?
Well, I think we have a very important year ahead of us next year. As Marie explained, that there is this international meeting in Stockholm in June, which will result in an outcome document that reflects the discussion. So the discussions will be really important in Stockholm. And from the enabling resolution that Marie referred to, we know it's going to be focusing on the environmental dimension of sustainable development, on implementing existing commitments, but also on the sustainable recovery out of the pandemic. So there are a couple of pointers which show us which direction this international meeting is going to take, and it's going to be very important to engage in the discussions in order to also influence the outcome document. And at the same time, as Jan was alluding to, we have this process going forward in Nairobi at the United Nations Environment Assembly, which has the second meeting of the fifth assembly is happening next year in February, where the political declaration will be recommended. It's not quite clear yet where the political declaration will be adopted, but a high-level political declaration will also be adopted. It may actually be in Stockholm, we don't know this yet, which is based on the United Nations General Assembly Resolution 73333, which Jan mentioned. And that resolution 73/333 contains a number of very good and well-formulated recommendations about the effectiveness and enhancement of environmental law and governance. So we have two possibility next year, and it's going to be very important to look at consistency between these processes and to work for a meaningful outcome, and hopefully one that combines everything together. But in terms of legal principles, I just want to make a general reflection here. Makane is absolutely right. We are missing predictability, certainty, and consistency. But I dare say that's probably the same with all principle. That's the nature of principles. We probably will never have completely determined content and meaning and scope of principle. They will always be, to a certain extent, indeterminate and remain a little fuzzy on the edges, because they never prescribe a particular outcome. But that's the beauty and the necessity of principles, that they can be applied to different circumstances and different situations. With regard to intergenerational equity, what we're seeing, we have references to intergenerational equity in international law, both non-binding but also legally binding law. And what are we saying? We're seeing national courts taking this principle and putting it into the interpretation of national laws, of constitutional laws. One example is the decision by the German Federal Constitutional Court from about a month ago, who established the principle of intertemporal protection of liberties. So we'd never heard of it before, but it was a very interesting and very forward-looking interpretation of constitutional rights based on an understanding of intergenerational equity. So we are seeing these principles being alive, being part and parcel of international law, but also seeing domestic lawmakers and courts now just taking them and applying them. But of course, we have the challenge of consistency and that they're not quite the same. But I guess that's the reality we'll have to live with. I don't think we'll ever see a complete beautiful puzzle of international law where every single piece fits together, but that's why we're working on it, and where every single academic can provide its little piece of work.
Thank you very much, Christina. Actually, at this point, we have a lot of of subject matter or a lot of material to open up for questions. I already I've seen that there are at least 9 questions so far. I will not, of course, take them all at once. I will take batches of 3, and my suggestion is that I will take batches of 3, and then I will simply open the floor to all panelists. So anyone who is tempted can give an answer to one or more as they see fit. And I will read, so I have questions from the chat and questions from the Q&A. So let me start by reading the first 3 that I received. So one is from Amber Pant. What makes the principles binding? What are the essential factors to make global principles binding principles in the light of customary and emerging as well as soft law and hard law principles? Okay, this is one question. Another question by Pau Vilches de Moraes. Pau, it's good to have you here. I mean, we know each other. Thank you very much to all of the participants for the very interesting presentations. To what extent do you think that courts, both domestic and international, can help to define the content, scope, and legal value of these principles? And then I will read a question from Nick Robinson, actually, that he made in the chat. And the question is for McCann, but again, this is, I'm opening the floor for any panelist. So Nick says, Professor McCann-Spenge's critique of the deficiencies of environmental principles can be applied to most non-environmental principles. Nonetheless, we accept general principles of international law, so why not accept the general principles of environmental law, like the right to the environment or the right to water? So I will stop there for now. So we have 3 questions. Let me open the floor. Let's try to address them all in, say, right now it's 2:18. Let's use roughly 5 minutes so we can take a second batch. Anyone would like to go first? Please unmute yourself. I mean, the 4 speakers, please.
Let me go then, Jorge, if you allow me, because there were several questions I see in relation to what I raised. No, I mean, of course we could go into long debates about all these aspects, and on principles. I don't want to reveal anything, Christina, about our discussions when we were working on the report of the Secretary General on gaps. But what I can say is that the report of the Secretary General underlines the need of having a comprehensive and unifying legal instruments for better harmonization, predictability, and certainty of principles of international environmental law. So I agree once again that many principles in the international system are characterized by generality, but it is interesting to see that in the very specific field of global environmental governance, there is, a more now clear consensus on the legitimacy or the usefulness of a comprehensive unifying instrument to render those principles more predictable. And this allows me to jump quickly, Jorge, on the question regarding the international courts and tribunals. So as I said, personally, I don't believe that it is for international courts and tribunals to act as lawmakers. I don't believe that judicial legislation is the key for the effectiveness and efficiency of global environmental governance. We all know that many of these courts, in particular interstate dispute settlement mechanisms, are very cautious, very careful in not giving too much weight. They would, for some of the principles, but for some other principles, they are very prudent, very cautious not to give too much legal weight to those principles because of the once again the unpredictability that is characterizing them. So I think international courts and tribunals, they need guidance. They need guidance. They need states coming with a stronger consensus via a more formal, comprehensive legal instrument to actually guide them in their interpretation and application. of principles of international environmental law. Let's not give the responsibility to courts to correct deficiencies in the system.
Other views from speakers?
There was this principle, this question about what makes principles binding on international law, I think. And I think that there are two ways. One is the codification into treaty law, and we talked about this. And we have several examples. What we don't have, as Makan and Jan was saying, is a treaty on principles, but we have principles included in many international treaties. And depending on the formulation, they are legally binding, or they're at least part of the normative structure around this treaty, and are often used in the implementation of that particular treaty or the further development of that treaty into protocols and so forth. So that's one way of having a bindingness nature of legal principles. And the other one is, as Makana was just talking about, is the development through the recognition of international customary law, which is based on an understanding of opinio juris. It's a legal opinion or legal understanding that something is binding as law, and it is also practiced by states in a more or less consistent manner over a certain period of time. And usually here we need an authoritative statement by an international court that something is custom, because otherwise we probably wouldn't know. And that is where the dynamism is currently developing. Or we have the International Law Commission, of course, who makes statements to this regard. But we're seeing a lot of development here. And then just one word on the right to a clean and healthy environment. I think there was one question here as well. I would be a little bit careful calling this a principle. I think this actually would be a right, a human right to a clean and healthy environment. And as such, it is being promoted, and the initiatives behind it are to recognize it as a legal right and not just an indeterminate principle. And there may be a difference in the legal context and nature with regard to a fundamental human right as compared to a more general legal principle.
Thank you, Mai.
Thank you. Just a short note. I'm a little bit along the line of Christina here and Makana, because I don't think that you give the courts a lawmaking function by the mere fact that they are interpreting something that may be a little bit vague or a little bit unclear. And that's why I think it is important, I mean, that courts can, through their case law, can contribute. It's better, it's going to be better case law if the principles that they interpret are very clearly written down. But we all know in international law, this is not going to be the case. Even if there is a treaty, they need to interpret the treaty. So this is why I think that the court cases are important. And if states do not want the courts to take over and to become lawmaker, the states better get their act together and make sure that they clarify the principles.
Thank you, Marie. I know that Jan actually is going to pass this one for the sake of allowing more questions. So I will take 4 questions very briefly, and then I will open the panel and we will end. So it's unfortunately time is running out. So I have this question from Laurence Döring. Jan, to what extent the Paris Agreement is a constitution? From Barbara Janusz Pauleta for Christina, how environmental law principles can best scale up climate law, the Paris Agreement? From Yin Yin Win, to what extent international law, I'm reinterpreting it essentially, to what extent international law can help meet the SDGs by 2030? And from Jose Antonio Titzman Silva, I'd like to have the opinion of the panel on the right to the environment. Can it be considered as being part of US Cogens norms? And then, in this condition, can it lead states to reconsider their resistance on going further and being bolder on the international environmental protection scene? So those are the 4. Again, I open the panel. Perhaps I start with Jan, and then we move to the other 4 speakers.
Merci beaucoup. Je vais essayer d'être bref. Donc, d'abord, l'accord de Paris, c'est un texte essentiel, mais ce n'est pas une constitution écologique du monde pour deux raisons. Premièrement, parce que c'est un texte sectoriel qui ne concerne que le seul sujet du climat. Il y a beaucoup d'autres sujets. Il ne traite que du climat. Il ne parle pas de biodiversité, il ne parle pas de produits chimiques, il ne parle pas. Donc, on n'a pas pour le moment, il n'existe pas de texte global qui prendrait l'environnement comme un tout. Or, tout est interdépendant. Et l'accord de Paris ne parle que du climat. Deuxième raison, c'est un texte technique, très technique. C'est un texte dont l'objet principal est la réduction des émissions de gaz à effet de serre. C'est ça l'accord de Paris, c'est tout. Et du coup, ça devient un texte très technique qui ne peut pas être lu par le citoyen lambda. Essayez de lire l'accord de Paris, c'est difficile de lire l'accord de Paris. Ce n'est pas un texte pour les citoyens. À la différence d'une constitution, d'une déclaration des droits de l'homme, ce qui manque, ce dont on a besoin, et c'est ça le pacte pour répondre à une autre question, c'est ce genre de texte accessible aux citoyens, qui soit accessible, que tous les citoyens peuvent lire, comme je le disais, le genre de texte qu'on peut mettre sur les murs d'une école, pour que tout le monde connaisse ses droits, ses devoirs et les principes en matière d'environnement. J'ai tendance à mettre tout ça ensemble. Je crois que certains principes se réfèrent à des droits, mais c'est une discussion de juristes qu'on pourrait avoir par ailleurs. Mais donc, c'est ce genre de texte. Et pour finir, parce que le temps est court, tout est possible. Chacun d'entre vous peut jouer son rôle. Tout va se jouer dans la dernière ligne droite, dans les derniers 6 mois. Et donc, pour nous aider, allez sur le site globalpactenvironment.org pour pouvoir nous soutenir. Et je finirai avec ça sans aller plus loin.
Merci beaucoup, Jan. Christina, what about the question that was addressed to you? So, environmental law principles can be scaled up for climate law.
That was to me, right, Jorge?
Yes.
That's actually a very interesting question. Environmental principles to scale up the Paris Agreement implementation, and I think that there are several aspects to it. One is that there are a number of environmental principles in the Paris Agreement itself. For example, it talks about that it will be implemented to reflect equity and the principle of common but differentiated responsibilities and respective capabilities in light of different national circumstances. Now, these principles are part and parcel of the Paris Agreement, and they have been used both by state parties to define their share of contribution to the global climate, or to reduce their greenhouse gas emissions, but they also have been used again by domestic courts to define what states need to do. And I already mentioned the German case, but just a couple of days ago, as you mentioned, Jorge, we had a judgment from a first instance courts in the Netherlands, in The Hague, who defined, or who told Shell, a private corporate company, to reduce its emissions by 45% in 2030, and that was partly based on an interpretation of the Paris Agreement and in the due diligence or duty of care of that corporation. In addition, we have two fairly innovative principles in the Paris Agreement. We have the principle of progression, that each time a party puts forward an NDC, it will go up in its level of ambition, and at each time an NDC is put forward, it will be at the highest possible level of ambition. The latter is a due diligence obligation to do as good as you can in your NDC and then do better each time or each 5 years around. So we have these principles in the agreement which actually can ramp up and scale up the agreement, and it can be done both to internal pressure and peer pressure, but also by pressure from civil society and stakeholders. And then in addition, we have, how can I say, outside pressure. We have, for example, the issue of what happens to climate damages if we really have losses resulting from climate change impacts. And here we don't really have much in the Paris Agreement that deals with it, and not in terms of liability and question of responsibility for these damages. And here international customary law may kick in with the principle of prohibition of significant transboundary harm, which could give us an indication of how to deal with climate-related damages and allocation of responsibilities. So I think all these principles in the Paris Agreement or around it, it's a whole ecosystem of principles can all be used in order to scale up and enhance the response to the threat of climate change.
Thanks, Christina. Marie, Makan, any last word? I mean, we have two questions open. One about the role of international law for the 2030 achievement of the SDGs, and the other about the jus cogens character of the right to an environment of a certain quality. Any last words, Makan?
I don't think that I'm the right person to discuss the jus cogens character of the right.
I think you're muted.
Is it okay?
Yep.
Okay?
Thank you. Sorry.
No, I was saying that I'm not sure I'm the right person to discuss the jus cogens character of the right to a healthy environment. I think that before we can talk about jus cogens, we would need a strong recognition by the international community, strong recognition and formulation of the right to a healthy environment before we can even start thinking about its jus cogens character. But something I wanted just to finish on quickly, Jorge, is that I think we need to admit that it is a reality. It is a reality that the legal uncertainty surrounding principles of international environmental law has a direct and indirect, impact on the implementation of sectoral environmental regimes. I think this is also something we need to take into account. I agree with Christina when she says, yes, in the Paris Agreement, non-regression, etc., are reflected, yes. But the fact that those principles do not benefit from predictability, do not benefit from certainty, do not benefit from consistency, creates unpredictability in the implementation of those sectoral environmental regimes, and then affect the effectiveness of those environmental regimes. This is what I wanted to finish upon. Thank you.
Thank you, Makan. Marie. Marie, any last word?
No, I don't have any last word. I think colleagues have just said it fine.
Thank you very much, Marie, and thank you very much. So I think that my last word is simply to thank you all, both the participants, the organizers, and the large and body of attendees were very active as well. I mean, I had many questions, so sorry about that. But, the times are what we're illuminating presentations, this discussion. Hopefully at some point in time, we will be able to hold them in person and have a glass of water, just to make it politically correct, just to have a glass of water after the end of the session. So thanks again very, very much. And remember, there is still on this IUCN week 4 more seminars, and 4 more seminars will be extremely exciting. So thank you very much for joining us today, and stay.
Unfortunately,
that was unfortunately a very quick exit of Jorge. Hopefully he comes back. But on behalf of the IUCN World Commission on Environmental Law, I would like to thank Jorge, I hope he hears it, for his masterful moderation of this webinar, but also, of course, to Marie and Makan and Jan and Nicolas, who is still around, for your discussions and sharing of your views and experiences. It was an invaluable discussion, and I really hope that the audience, we had quite a significant audience, enjoyed it as much as we did. And many, many thanks, of course, also to Emily Gaskin, who was responsible for the technological challenges here in the background. I just wanted to mention that there is a recording of this seminar or webinar that will be available at the IUCN World Commission on Environmental Law's website in due course, as of all the other environmental webinars we do. And I just wanted to bring to your attention that the next webinar is already tomorrow. It's each day this week, but tomorrow at 2 p.m. European time, CEST, and it will be looking at climate change. We just finished with climate change and we start again tomorrow. And we're looking at the interlinkages between climate legislation and litigation. So the written law as compared to the spoken law, what are the dynamics between that? And we all invite you back tomorrow at 2 p.m. and hopefully see you then. Thank you so much for today, and stay well and stay safe. Bye-bye.
Thank you,
Merci.
Christina.
Bye-bye.
Thank you.